Muy buenas tardes. Ustedes están escuchando a WNHH 103.5 FM LP, La Voz Hispana Radio desde Downtown New Haven, y estamos streaming live a través de La Voz Hispana CT en Facebook, YouTube, X y otros medios sociales. Esta es Norma Rodríguez-Reyes, su anfitriona en el show ¿Qué pasa? Bueno, hoy en día vamos a hacer algo que casi nunca habíamos hecho. Esta entrevista va a ser solamente en inglés, pero más tarde vamos a buscar a una persona que pueda hacer esta entrevista en español para que así toditos los que hablan inglés y los que hablan en español puedan tomar ventaja de esto que es muy necesaria. Okay, bueno, tenemos, we're going to be doing something that normally we never do, which is, this is going to be an interview only in English, but we will later on find someone that is very capable and can do this in Spanish. But attorney Maureen Martowska, and she's a retired corporate attorney, Juris Doctor from the University of Massachusetts School of Law, and most of her life she's worked as a technical writer for a defense subcontractor such as Raytheon. Oh my goodness, Raytheon, and working on highly classified government documents. And attorney Martowska has been a strong advocate for parents' rights since 2005. She believes the courts being accessible to all parents, including those with mental, physical, developmental, and intellectual challenges, and strongly supports shared parenting. We've been going through. Today we're going to highlight a much-needed bill, especially in the wake of recent two cases in Connecticut where perhaps if grandparents had been involved, this could have been different. The story would have been totally different. One is the New Britain case of Mimi Torres Garcia, the 11-year-old starved for over a year and found dead in a trash bin. And also the case of the Waterbury of a boy held captive for 20 years by his stepmother, and the son was 5 feet 9 inches and only weighed 68 pounds. So that is why we have attorney Martowska here to talk about Martowska to talk about this issue. Thank you so much, attorney, for being here with us today.
Oh, thank you for having me. I appreciate this opportunity.
So we're going to talk about, you have the Grandparents' Day. Can you talk to us about the Grandparents' Visitation Rights Rally?
Yes, not this Thursday, but next Thursday on April the 23rd from 10 a.m. to noon on the north steps of the Capitol here in Hartford is a very important grandparents rally. And really, to be honest, it's a better name for it would be grandchildren's rights. Grandchildren have the right to familial integrity, the same as all adults do. And poor Mimi and the other individual who was in Waterbury, these children fell through the cracks because there weren't enough access, we believe, by grandparents that could have possibly have interceded. In fact, we know in Mimi's case, a grandmother had tried to intercede and was rejected. And it's time to get serious about what's happening in Connecticut. These two recent cases particularly highlight it, and we're asking for grandparents, parents, brothers, sisters, aunts, uncles, if you've been impacted by loss of access to your family and your family you felt was at particular, the children were at substantial risk of harm, this bill addresses that issue and perhaps acts as a stopgap to prevent these situations in the future. We need everybody to attend within the sound of my voice who really want to support grandchildren's rights.
So, Attorney Martowska, where is this rally going to be taking place and at what time?
It's going to be taking place in Hartford, Connecticut at the Capitol building, the North Steps, and it will be from 10 a.m. to noontime. We expect to have some legislators there that will speak, as well as myself, regarding the details of the bill itself.
Very good. So, Grandparents Visitation Rights Rally, Protect Our Children. Grandparents must prevent harm to children before DCF gets involved. And it's going to be taking place on April 23rd at 10 o'clock in the morning, North Step of the state capitol. Prevent harm to grandchildren at risk of harm. And so everyone is invited to this event. And now at this time, we're going to go into the actual bill that is being proposed before the legislature. But so, Attorney, tell us a little bit. Can you tell us a little bit about yourself?
Yes. Well, I was born in Hartford, Connecticut, raised in Connecticut, in Windsor, Connecticut, with a large family of, there were 6 children and my parents. Right now, I live in Massachusetts, but outside of my son and daughter and their family that live in Massachusetts, all my extended family are right there in Connecticut. I have been involved in Connecticut in the family courts for a prolonged period of time, working for a very long time with parents on protecting their rights. And parents are very important to me. I got involved with the GAL reform back in 2014 and was a key figure in getting the ethics code implemented there. When parents were finding that guardian ad litems were overbilling them, they were operating with limited oversight by the court. There were high costs and insufficient training. The key outcomes that I've produced in Connecticut is that I got to make sure that there was improved training on domestic violence, and there was choice in selection of the guardian ad litems, that people of low income who couldn't afford these guardian ad litems were given a sliding scale. And also, we prohibited GAL fees from being paid out of a children's college savings funds. Really very important things for parents. I'm also a member of National Alliance on Mental Illness. I had a bachelor's degree in English from Amherst College, a JD from UMass Dartmouth. And as you said, I became a lawyer. And it was at the age of 50 and trying to help my mother, who was significantly challenged with disabilities. And that has been the basis of my general background.
Maureen, tell us what is guardian ad litem? Because a lot of people, unless they've had one, they probably
Yes.
don't know what that is. So explain to that.
Okay, so a guardian ad litem, anybody who's been going through a divorce that has a high conflict case, meaning the parents can't agree with each other on custody issues. A lot of times, these cases involve some mental health component as well. And typically the judge will assign a guardian ad litem to really review the case, see where the real facts lie, and try to look out for the best interests of the child. And then he or she will give a recommendation to the court as to visitation, custody, those matters. But what we found out was that was being abused. We found out that in many cases, guardian ad litems were finding they were on these cases for many years. And we had to address that issue because they were depleting, parents' resources financially.
Yes. So tell us, how did you get involved in this?
I personally was involved for 2 reasons. I had some attorney friends in Connecticut that had reached out to me noticing what they would, they saw some bizarre things going on, let's say with the guardian ad litems. And then secondly, I had a son who had a divorce case in Connecticut, and I became very familiar being engaged from 2005 until 2000, I want to say it was 2020, somewhere around there.
Mm-hmm.
So for 18 years till the child aged out, I became very familiar, both from a personal level, seeing what a parent goes through as a grandparent, I've also seen that. And most importantly, as a lawyer, observing what goes on in the court.
Hmm. Okay, so tell us about the current Connecticut grandparent statute.
Well, the current statute we found deficient. I had many loving grandparents who had approached me and said, gee, we have certain circumstances where we felt that our grandchildren were at risk. And the current statute as it is, um, the current statute is known as CGS 46-59. And that is a statute that allowed anyone, not just grandparents, to petition the court. And that statute came about really as it had actually been developed, let's say, through the years after Troxel v. Granville. That was a U.S. Supreme Court case where there was a grandparents that wanted access to their grandchildren. And the Supreme Court case said in this particular situation back in 2000 that parents have paramount authority. It's under the 14th Amendment of the Constitution that protects the parents' right for the care, custody, and control of their children. It is presumed that a parent is fit, and because they are fit, they are acting in the best interest of their children. Connecticut had respected that, but in our case, we feel that many grandparents have felt that that was an overreach, because nowhere in that U.S. Supreme Court case did it say that you have to be in a parent-like position. Currently, Connecticut statute requires that you be in a parent-like relationship, number one, and number two, that you have real harm. You must prove those two prongs in order to have what they call standing to bring a case or a petition for grandparent visitation and then have a hearing on that. If you cannot do that, you are defeated. And to be honest with you, we had heard feedback from grandparents when the judges had said, look, my hands are tied. I've tried it. I have to abide by the law. That parent-like relationship is an extremely difficult hurdle to overcome. It's industrial strength. Even being with a child 6 days a week, 8 hours a day would not suffice. We have seen many grandparents who had adult children who were suffering from mental health concerns, and still the grandparents could not have access to get help for the grandchildren. So that's currently what the state of Connecticut has as far as the grandparent statute, those two important prongs.
So many people think that grandparent visitation is about grandparents, but you say it's really about children. Can you please explain that?
Yes. With regards to grandchildren, they're not voters. They don't have a voice, and they're the most vulnerable. And we are respectful of parents' rights to make the decision in the best interest of their children. However, the state has a duty when there is a substantial risk of harm to the child's safety and welfare. In law, it's called parents' patry doctrine, that the state has an obligation through its courts or through DCF to get involved and intervene to make sure the children are safe and protected. In the cases of Mimi in New Britain and the case in Waterbury, I have to believe, and I think most reasonable people would believe, that for a child to come to the state of being starved to death, and for a young boy to develop only to a very meager development of 68 pounds, that something's wrong, and that those type of things could have been hopefully helped if there was some intervention of some type. As I said, there's a mental health component to this about what we're trying to do with this bill, and that is that, when parents don't take care of their children the way they need, and this is not a condemnation on that, but many parents are sometimes have mental health challenges. They need help. The grandchildren need help. In Connecticut, NEMI, National Alliance of Mental Illness, has stated that there are 531,000, that's over 500,000 people with mental illness, a mental health condition, I'll say. In addition to that, 121,000 adults have a serious mental illness. What does that mean, and why do we need the state to get involved? And are we really trying to supersede the parents' rights? The answer to that is no. We're trying to protect the grandchildren. That's exactly what our bill does, because what we're doing with our bill is we're, number one, saying you don't need to have a parent-like relationship. We don't believe that's what Troxel v. Granville, the U.S. Supreme Court, said. In fact, it was not dispositive on a parent-like relationship. It was, what it did say was that parents have paramount authority. Mm-hmm. However, the state does have a duty, and more importantly, an obligation to intervene in these cases when a child is at substantial risk of harm. We know with serious mental illnesses, and this is, again, a piece of the education that people may not realize how important this bill is. This is important because when you realize that there's a serious mental illness, 50% of the people with a serious mental illness often have a condition called anosognosia. That's a lack of insight. It's a lack of judgment, in fact, into their own condition if they need help. And that means that these parents can't act proactively to make sure that their kids are safe sometimes. Mm. By the same token, I want to just say something. This is not an indictment on anybody with mental health conditions or serious mental health issues. It deals with unmanaged mental health issues. But also, it allows grandparents, in addition to that, who think that their grandchildren are at substantial risk of harm for whatever reason, to petition the court.
So, Attorney, you have spent time advocating for changes to Connecticut's grandparent statute. Why do we need the law changed, and what changes do you hope to make that would protect children?
Well, one of the reasons we need it is we're given the two examples of the New Britain case and the Waterbury case. Connecticut seems to be failing grandchildren who are in harm's way, and the state has a duty to protect them. Legislators right now are making a Band-Aid approach, looking to make do you qualm this public outcry from these two horrendous cases. They look to homeschoolers, and they say, well, maybe there's something we can do by having the Department of Education send a note to DCF. And DCF, the interim commissioner, has testified in front of the legislators that she's not mandated to do anything, even if she got that note. And neither should it be blamed that homeschoolers are people that have to be looked at with more scrutiny. The second thing the state's tried to do is they've said, okay, well, DCF, we have to empower them more. DCF has over 70,000 calls per year. I said, 70,000. And they have, out of those 70,000, approximately 35,000 are opened up for investigation. The state previously was under a consent decree under the federal government because for 5 years, I believe it was, because they were not able to adequately they didn't demonstrate adequate oversight over the children in Connecticut. Judges claim their hands are tied. This is another reason why now we need to do it. And we know these cases have occurred. What can we do? We need to make awareness of the connection to an extended family that these grandchildren have. Their ethnic diversity and their family history can only be transmitted orally and over a long period of time. This is all being lost when grandparents are cut out. And again, this is narrowly tailored. It's not that all grandparents will have access, but some legitimately should have access, and the judges should be given the flexibility to make that decision.
Okay. So, attorney, you have said that your goal is not to take away parents' rights, but to protect children. Can you explain that balance?
Well, we're trying to adhere to the Constitution, the 14th Amendment, and respect that all parents are presumed fit and that they do have the right to the care and custody and control of their children. As grandparents, we should respect that. We also know, though, that grandparents also are in a unique circumstance when mental health is not being well managed, and children can be at substantial risk. Everything has been looked at, by the state as to how we can address these issues when they talk about how can we try to protect the grandchildren. But really, had they looked at the source of what the issue was, the mental health component, where these two other children likely had issues, and yet for some reason the parents were not able to take care of this issue. Instead, it ended the way it did for these two children. In these cases, the state, through its family courts, should entertain petitions for access by grandparents who can more readily observe and see the gradual unveiling of perhaps mental illness well before the harm is done. DCF comes retroactively after the harm has been done. We want to be proactive, and that's very important. So when we see Connecticut addressing bills, for instance, with cans and recycling and not prioritizing children, it's important that we bring awareness to this grandparents' bill and get the support we need.
Now, if I'm not mistaken, the bill, there was a part of the bill that passed the House but did not pass the Senate, did not go through the Senate. Are we back in the House again, or where are we at this time?
Well, right now, I know that I and several other grandparents have met with the joint the co-chairs on the Judiciary Committee. We tried to educate them on this bill and what it would do for grandchildren. We also have tried to speak with other legislators. The bill was given an LCO number 0926. Never yet formally assigned the bill number that you would typically see. And the feedback that, we have this time is that it is stalled, basically. It hasn't been brought forward as far as a priority with the Judiciary Committee, and we're trying to get attention to this bill so that it will be made a priority, hopefully during this session.
Okay. So we're definitely planning a rally to bring awareness. And what do you hope people will understand?
I would hope that they'd want to understand that this bill ensures grandchildren are safe and that we need their help to make it. Cannot happen by, one or two grandparents willing to speak out about this. It needs a family. It needs a village. It needs people to speak out for the children because they do not have voices. And if you were outraged by the two recent cases in Connecticut, you need to join this rally. This is your moment. This is your time. A lot of work has been put into this bill, research and getting the support we need with legislators. And lastly, I'd say to date, we've gone to bat as much as we can. If you come to the rally, it doesn't have to be a grandparent. It can be anyone in your family that supports this bill, supports the safety and welfare of children. Call your legislators, tell them that grandchildren need to be a priority and keep them safe. And they need to pass Grandparent Bill LCO number 0926.
Thank you. Is there any place that they can call or get in more information if they're interested?
They can go to the Connecticut Grandparents' Rights Facebook page. If they go to that page, they can search that on their bar on their Facebook, and that will give them that will get them to the Facebook page for Connecticut grandparents' rights.
Maureen, is there anything else you'd like to add?
I would say to any loving parent to understand that this is not trying to supersede your right. It is not. It is trying to keep children safe in those very unique situations and challenging situations where the child is at substantial risk. And the difference between a child's life and death might be the access of a grandparent.
Thank you so much. I really appreciate you having been on the show. I wish you best, and I hope to see everyone at the rally, right, on April 23rd at 10 o'clock in the morning, and it's going to be at the state capitol, right?
Yes, exactly.
In the north part, right?
North Steps, yes.
North step of the state capitol in Hartford, Connecticut.
Yes. Thank you very much.
Thank you. I
Norma.
really appreciate it. Bueno, como mencioné, esta entrevista fue en inglés. Más tarde la vamos a hacer en español para que las personas sepan sobre los abuelos, que los abuelos necesitan estar envueltos en las vidas de los jóvenes, de los niños, especialmente esos niños que tienen problemas mentales, así sea físico o psicológico, igualmente que muchos de los padres también pueden tener esos tipos de problemas. Gracias por estar escuchando. Ustedes están escuchando a WNHH 103.5 FM. Thank you so much for listening. You've been listening to WNHH 103.5 FM from downtown New Haven, streaming live on Facebook, YouTube, X, and other media. This is Norma Rodríguez-Reyes, your show in K-PASA. Health, money, and love, and plenty of time to enjoy it. May we live to be 120 in good health. Thank you so much. Maureen, thank you so much, and wish you the best, always.